If one of the things you have to deal with this year is unfortunately a severance agreement, don't be afraid, don't lose hope. This video is for you. Always have it evaluated by an attorney. But in this video, I'm going to be breaking down what a severance agreement is, how you can negotiate more money in your severance agreement, what it costs to hire a lawyer to facilitate those negotiations, and finally, I'll introduce some common provisions that I like to see in almost every severance agreement that are unfortunately overlooked by employees. But first, all the information I'm sharing today is of a general nature, specific to the state of Washington, but not specific to your legal case. If you have questions about your case, you should reach out to an attorney. Let's get started. A severance agreement is often a voluntary agreement provided by the employer to the employee in order to limit the legal exposure or potential legal exposure to the employer. So what does that mean? Well, I get phone calls all the time from employees that are called into the office by their boss where there's an HR professional there serving as a witness, and the boss will tell them that they're firing the employee for performance reasons. Now, almost always the employer will say that they're firing the employee for performance reasons because they want to dispel any notion that they're firing the employee for the real reason, which may be a wrongful termination, retaliation, sexual harassment, something like that. The employee will get the severance agreement and they will sign the agreement, unfortunately, without having it reviewed by an attorney. Even where it contains a nominal sum of money, there may have been a basis to negotiate more, and it will include non-monetary provisions, which I'll talk about later. Now, severance agreements also show up in contract as well. I've experienced where employees forget that they were promised severance agreement or severance pay when they first signed up for employment. I've also seen, of course, in high-level CEOs, CFOs, where there's a contract in place that provides for post-employment compensation. And of course, physicians. Physicians are a unique profession where there are employment contracts in place as well. Now, there are many different fee agreements an attorney can have with the client regarding their severance negotiations. However, two of the most common ones are one, hiring the attorney by the hour, which may make sense if you have the financial means to do so. But if you lack the financial means, more often than not, an attorney is hired on a contingency fee basis. Now, this is a little different than what most people think of as a contingency fee basis in that it's not a pure contingency fee basis. Very different in a car collision or personal injury matter where a third or fourth is taken out of the entire settlement. A lot of the employment statutes, state and federal law, allow for the recovery of attorney's fees, where essentially, I'll make a video about this later, where the employer will pay the legal fees of the employee if the employee is successful. So those are the different ways in which an attorney is hired. One caveat I'll say is that oftentimes an employment attorney, including myself, will not take a third or 40% of whatever the client comes in with. So let's say a client is brought in with a 1-month severance agreement. Well, if negotiations failed, I would never take a third or fourth of what's already been offered, even though I've contributed my time and even though negotiations have failed. One thing to consider regarding hiring an attorney is that if negotiations fail, in theory, you're going to be with that attorney when they potentially file a lawsuit and go through this matter through litigation and potentially a trial. Lastly, I want to talk about some non-monetary provisions that often show up within a severance agreement. First of which is what's called a non-disparagement clause. Now, this is often put in there by the employer that prevents the employee from saying anything bad against the employer. You can imagine an employer does not want to read anything on Glassdoor or some sort of review site about the terrible experience the employee had. But it doesn't often go both ways, and this is why I like to include what's called a non-disparagement clause or non-disparagement agreement. What this does is it prevents the employer from saying anything bad about the employee. Oftentimes, the employer will be limited to disclosing the dates of employment, the compensation, the fact that the employee was employed, and perhaps the job duties. They can't say anything that the employee was put on a PIP plan or had a bad attitude or was late, anything like that. Lastly, I like to remove the word termination from anywhere within the agreement. There is no reason for this word where we can simply include voluntary separation. Even though the agreement may be confidential, I don't want any language that is going to haunt the employee when they look for employment elsewhere. So for example, they apply for a job and they see a checkbox that says, have you ever been terminated from a job? Well, if somewhere within the agreement or somewhere elsewhere the employee is terminated, well, they would have to answer truthfully. And so I like to avoid that language entirely. Thank you so much for watching. If you liked this video, please let me know. If you didn't like this video, I want to hear from you as well. Lastly, if you need the help of an attorney and you're not sure where to go, I cannot recommend enough the Washington Employment Lawyers Association. I'll include a link below for that. These are attorneys that predominantly represent employees. These are people like myself. It's a great organization. Don't go it alone. Thanks again for watching.